Marcus didn't see the traffic stop coming. He was driving home when the light hit his mirror. Routine traffic stop until the officer found a small amount of a controlled substance in his backpack. Suddenly, Marcus was in handcuffs, running the math in his head. Felony, prison, his job gone, his family finding out, because that had always been the assumption. Drug possession in Oklahoma means a felony record, and the felony record changes everything. Except Marcus was wrong, or at least not completely right. The law had changed. Today, many simple drug possession cases aren't filed as felonies anymore. But before you breathe a sigh of relief, there's a catch. One mistake that could turn what should have been a misdemeanor back into a felony case, and it's a trap that catches people every single week. For a long time, getting caught with any amount of drugs in Oklahoma meant one thing: a felony charge. Didn't matter how small the amount. Didn't matter if it was your first offense. Possession of a controlled dangerous substance carried felony weight in the state. That meant the Department of Corrections, not county jail. That meant a criminal record that could follow you everywhere. Jobs you couldn't get, apartments you couldn't rent, professional licenses put in jeopardy. One arrest and the path forward got a lot harder. Then, on November 8, 2016, Oklahoma voters passed State Question 780. It took effect on July 1, 2017. What it said was clear. Simple possession of a controlled dangerous substance is now a misdemeanor, not a felony. The first offense, you're looking up to 1 year in county jail and only up to $1,000 in fines. That is still a criminal conviction. That is still serious, but it is not a prison sentence, and it's not a felony record permanently attached to your name. Now, here's what no one tells you about the way the new law actually works. State Question 780 didn't put a ceiling on the consequences forever. Oklahoma built a system on top of it. In 2023, the legislature passed what people are calling the four strikes law. And in practical terms, what that means is this: the penalties escalate with every conviction. And by the fourth one, you risk being back at felony territory. First offense, simple possession, no convictions. That's a misdemeanor. Up to 1 year in county jail, up to $1,000 in fines. A court will also likely order a substance abuse evaluation. Second offense within 10 years, still a misdemeanor. But now, a judge can order you into drug court. That is a structured program with weekly check-ins, regular drug testing, treatment requirements, and most of the costs come out of your pocket. It can run up to a year as well. I want to be straight with you. Drug court is not a light touch. People underestimate it until they're in it. The third offense of the 10 years, now there's a risk of mandatory jail time. No way around it. Plus up to 3 years of probation and intensive outpatient treatment. You're technically still facing a misdemeanor charge, but the consequences have escalated significantly. Then there's the dreaded fourth offense within 10 years, and that is the trap. The fourth conviction is now classified as a felony, 1 to 5 years in prison, up to a $5,000 fine. You walked in thinking you were dealing with a misdemeanor situation, and you walk out with a felony record that State Question 780 was supposed to prevent. I've talked to people who had no idea this escalation existed. They assumed State Question 780 meant drug possession in Oklahoma was essentially handled forever. It is not. And the ladder is real, and a lot of people don't see the top of it until they're already climbing it. Now, let's talk about what possession actually means under Oklahoma law, because that is where a lot of people get blindsided before the case even gets started. Most people think possession means the drugs were on your person, in your hand, in your pocket, in your bag. And yes, that qualifies. But Oklahoma also recognizes what's called constructive possession, and that is where things get complicated. Constructive possession means you didn't physically have the drugs on you, but prosecutors can argue you had control over them and knew they were there. If drugs are found in your car you're driving, in a room of your home, in a bag you were near, you can be charged with possession even if you never touched the substance. I've worked cases where my client was genuinely shocked to be facing a charge because they weren't their drugs. That may be true, but knowledge and control is what the law examines. And prosecutors will use your location, your proximity, prior text messages, prior history, and anything they can use to build the argument. Here's the other thing most people do not see coming. Oklahoma law has specific weight thresholds, and if the amount found crosses one of those thresholds, you're no longer looking at possession, you're looking at drug trafficking. And trafficking is a felony with mandatory minimums and serious risk regardless of anything State Question 780 says. The threshold varies by substance. For methamphetamine, it's 20 grams. For cocaine, 28. For marijuana, 25 pounds. And for fentanyl, and this matters right now, given what's happening in Oklahoma, it is just 1 gram. 1 gram of fentanyl, a sugar packet worth, and a prosecutor can file trafficking charges. That's not a misdemeanor. That's a felony with the risk of serious prison time. Many trafficking convictions also qualify as 85% crimes, meaning you serve at least 85% of your sentence before you're eligible for parole. Trafficking does not require proof that you are selling anything. It does not require a transaction, an intent, a text message about a sale, or a single witness. It is based entirely on the quantity of drugs found. The law assumes that above a certain weight, a person has more than personal use in mind. I've seen clients caught completely off guard by this distinction, caught with what they thought was a personal stash, and found themselves facing trafficking charges because the weight hit the statutory threshold. Have you or someone you know dealt with drug possession situation in Oklahoma? Drop a comment below. I hear these stories more than people realize, and you'd be surprised how many people had no idea about State Question 780 or the 4 strikes law until they were already facing charges. So what are your actual defenses if you're facing a possession charge in Oklahoma right now? The first thing I want you to hear is this: a charge is not a conviction. There are real, legitimate arguments that you and your defense team can make in these cases, and which ones apply depend entirely on the specific facts of what happened in your case. A legal search and seizure. How did law enforcement come into contact with you or even find the drugs? If a traffic stop lacked reasonable suspicion, if a search happened without your consent and without a warrant, that evidence may be suppressed or kept out of court. When evidence gets thrown out in drug cases, the charges often go with them. This is one of the first things we examine in any drug possession case, and this is one of the most effective tools available: lack of knowledge. Prosecutors have to prove you knew what was in that bag, in that car, in that room. If you generally did not, a bag someone handed you, a car you borrowed, a shared living space, lack of knowledge is a real and valid defense. The burden is on the state to prove you were aware of what was there. Chain of custody. How was the substance handled after it was seized? Was it properly documented, tested, transferred, maintained throughout the process? Breaks in that chain of custody create reasonable doubt that what was found at the scene is actually what has been tested and what you've been charged with in court. These procedural details matter far more than people expect. One more thing before we close. If someone has ever told you that you should plead guilty because it's only a misdemeanor, I want you to think very carefully before accepting that advice. A conviction is still a conviction. It shows up on a background check. And if you ever face a second or third possession charge, that first plea is what starts the clock on the 4 strikes escalation. The decision you make today shapes what happens in your future. Make sure you understand exactly what you're agreeing to before you walk into that courtroom. If you're dealing with drug possession charges in Oklahoma, my video on Oklahoma drug charges covers what your potential sentence looks like and what options are available to you. Link is right here. And if you need to speak with an attorney about your specific situation, contact information is in the description below. Drop your questions in the comment. I read every one of them.